A governor of Reserve Bank of India, he do have a complete authority to suspend the operations up to 30 days. For a time being, it had adopted certain clause under a Companies Act 1956. Other than the Companies Act 1956, it won't follow any kinds of laws. In terms of emergency situation, the deputy governor which had nominated by central government, he do have a complete right to suspend the duties. Hello everybody, a warm welcome to one and all. I am Mr. Hemant Kumar from the Department of Commerce and Management, Vidhyaashram First Grade College, MYSURU, the Temple of Excellence. In today's session, we are going with the subject Banking Law and Practice, that is session 1 of Unit 2, that is Banking Regulation Act 1949 for first semester BCom students. This is agenda of today's session. We are going with the concept of Introduction to Banking Regulation Act 1949, and also we are going with the part 1 of Banking Regulation Act 1949, that is preliminary. These are the two topics we need to cover in today's session. Introduction to a Banking Regulation Act 1949. What exactly this Banking Regulation Act 1949 is about? Hope you people are familiar with the Companies Act 2013 and Companies Act 1956. So, Companies Act 2013 or 1956, it make a regulation for the companies, right? So, it is going to make a regulation for a companies. But when it come in terms of a Banking Regulation Act 1949, it make a regulation for a banking companies, right? It is going to make a regulation for banking companies, which a banking company must follow. It is going to describe do's and don'ts of a banking company. Say for an example, collecting a deposit and lending a loan is a main function of a banking company. So that is prescribed in a Banking Regulation Act 1949. And also, according to Banking Regulation Act 1949, this banking company must not involve in any kind of a trade activity. That is a rule that is made by a Banking Regulation Act, right? So these are all the things that we need to study under a Banking Regulation Act, right? That is what we are going with. This Banking Regulation Act 1949 had started as a Banking Companies Act 1949. At the beginning, it had started as a Banking Companies Act 1949, and later it had modified into Banking Regulation Act 1949, right? This act came into force on 16th March 1949. So this Banking Regulation Act came into force, started its operations from 16th March 1949. So this act monitors day-to-day operations of a bank, means which are all the activities that is going to happen routinely in a banking company. This act is going to take care about, means do's and don'ts. So on which are all the banks must follow this Banking Regulation Act 1949. So the banks which is available inside India, means the Indian banks must follow this Banking Regulation Act. The banks like commercial banks, cooperative bank, rural banks, and private sector bank that is existence in India, right? So where these banks are available in India, they are supposed to follow what? Banking Regulation Act 1949. This act give Reserve Bank of India a power to control a behavior of banks. So these banks give a special power for a Reserve Bank of India as a banker's bank, because this act give a authority or a power for Reserve Bank of India to give license for a private banks. Banking Regulation Act 1949 gave Reserve Bank of India a power to control all the functions of a banking companies. A company which had registered under a Banking Regulation Act 1949 must follow this regulations, means which is made by Reserve Bank of India. A special power that is given by Banking Regulation Act, Reserve Bank of India have the authority to issue license for the banks, right? So if any kind of a bank must be established, so it is the obligation of a banker to take a license from the Reserve Bank of India. Say for an example, there is a HDFC Bank, IDBI Bank, right? So ICICI Bank. So they are supposed to do what? They are supposed to take the license with Reserve Bank of India, right? So until and unless Reserve Bank of India approve their license, so they are not supposed to go with operations of a banking, right? They are supposed to take a license from a Reserve Bank of India. That power is given by Banking Regulation Act to Reserve Bank of India. Hence, this Reserve Bank of India, we call it as a bankers bank, because the Reserve Bank of India have a complete power to give or issue a license for a banks, right? So, hence we call it as a bankers bank. It is a duty of a Reserve Bank of India to control a bank and also to govern the operation of bank and also supervising the banks which comes under a limit of Reserve Bank of India. Means all the banks that had registered under a Banking Regulation Act 1949 must be governed and supervised by a Reserve Bank of India. It is an act which is going to give a framework for the regulating or a regulatory functions of a banking company. Means it is going to make a regulations which must be followed by a banking companies. This Banking Regulation Act 1949 was not applied for a state of Jammu and Kashmir till 1956, and after 1956 it is applied for a state of Jammu and Kashmir. Means all the regulations that comes under a Banking Regulation Act 1949 must followed by all the Jammu and Kashmir states. Part 1, that is preliminary. So we are going with the Part 1 of a Banking Regulation Act 1949. So this Part 1 is going to say about a preliminary. So what is this? A preliminary is about. Preliminary means it is a prelim, means it is going to give a basic thing that the banking company is going to do, why the banking company is in existence, which are all the activities that the banking company is going to do, and which are all the activities that the banking company must not do. It is going to give a brief introduction about a banking companies, right? Here under a prelims we are going with 6 sections, right? So under a prelims, we are going through 6 sections. Section 1, Section 2, Section 3, 4, 5 and Section 5A. These are the 6 sections we need to go under preliminary. Under Section 1, it is a short title, extent and commencement. It is going to say about a short title of a Banking Regulation Act, the extent and a commencement, right? Section 2, application of other law not varied. So there are some law which is not applicable for a banking company that we are going to learn here. Section 3, act not to apply for certain cooperative society. This Banking Regulation Act must followed by only a banking company. It is not applicable for other commercial or a financial institutions or non-banking companies. This Banking Regulation Act is not applicable for non-banking company. It is applicable only for a banking company. Section 4, power to suspend operations of a act. So here this under a Banking Regulation Act, so there is a power for a act for the suspension of a order that is given by a central government. Under Section 5, we are going to learn about a interpretation. So it is going to interpret 3 terms that we need to study. Section 5A, act to override memorandum and article. So as we know, each and every registered company have their own memorandum and articles of association. So under a banking company, what this articles and memorandum of association is about, we need to go with. Part 1, preliminary. So as I said, part 1 is about preliminary. So it is a basic thing that we must know about a banking company. Under Section 1, we are going to study 3 things, that is short title, extent and commencement, right? That is short title, extent and commencement. So under Section 1 of a Banking Regulation Act 1949, the short title that is given to the act is a Banking Regulation Act 1949. Means it is going to give a regulatory framework for the all kinds of banking company that we call it as a Banking Regulation Act 1949. This is a short title that is given by this act. As I said earlier, this act was named as Banking Companies Act 1949 and later it was renamed as a Banking Regulation Act 1949. It is a short title that is given by a act. Extent. Which are all the states of our nation this Banking Regulation Act 1949 is applicable? It is applicable for all the states of India, our nation, right? Including states of Jammu and Kashmir. So before 1956, it was not applicable for a state of Jammu and Kashmir. So now it is applicable for states of Jammu and Kashmir. It is applicable for whole India, including the states of Jammu and Kashmir. Means all the banks that is present in the state of Jammu and Kashmir also must follow this Banking Regulation Act 1949 norms. Commencement. So as we know, it had commenced on March 16th, 1949 as notified by a central government through an official gazette. So this official gazette is a official notification or a circular that is circulated by a central government, which must followed by all the banking companies. And also, according to section 1 subsection 3 of the act, the commencement date was specified by central government through a notification which was published in a official gazette. Means a commencement of a Banking Regulation Act 1949 is published by a Government of India. Means the date of commencement is decided by Government India and it had implemented. Means which are all the norms, which are all the things that is included in the complete Banking Regulation Act is completely controlled by Government of India. So briefly, if we come into section 1, according to section 1, it is going to state three things, that is short title, extent and commencement. So in terms of short title, it have a very short title, that is Banking Regulation Act 1949. Earlier it was named as a Banking Companies Act 1949. Again, extent, it is applicable to whole India, including a state of Jammu and Kashmir. Commencement, it had commenced on the date, that is 16th March 1949. Section 2, application of other laws not varied, right? So there are some laws which cannot be applied for a banking companies. Say for an example, Companies Act 2013 is not applicable for a banking companies, right? So according to section 2 of a Banking Regulation Act 1949, the provision of this act are addition to and not derogation of other laws. Means it is an addition to a banking company and other laws is not applicable under a banking company. For the time being, in force, a banking company is following a Companies Act 1956. For a time being, it had adopted certain clause under a Companies Act 1956. Other than the Companies Act 1956, it won't follow any kinds of laws. This implies that the Banking Regulation Act does not supersede or override other applicable laws, but rather complement them. Means according to this law, banking company is not follow any kind of a law. It must follow only what a Banking Regulation Act 1949 and a part. For the time being, it had adopted, that is Companies Act 1956, few clause of a Companies Act 1956. For example, Companies Act 1956, a Banking Regulation Act does not replace or modify a Companies Act 1956. So it is going to say that a Banking Regulation Act, it does not have any authority or a power either to modify or replace Companies Act 1956. It is not supposed to make any kind of a regulation under a Companies Act 1956. Just it must follow certain clause that is given by Companies Act 1956. So which are all the things that the banking company had adopted from Companies Act 1956? That is regulations regarding incorporation and management of companies and also including banking companies. It is going to regulate what? Incorporation of the company and management of a company, including banking companies. According to section 3 of Banking Regulation Act 1949, it is going to say about act not to apply to certain cooperative society. This Banking Regulation Act 1949 is not applicable for certain cooperative society because there are number of cooperative society that is available in the market, right? So which is going to render the service of a banking company, but for such kind of a cooperative society, this Banking Regulation Act 1949 is not applicable, but it is not a banking company. Hence, it is not a banking company, it's a cooperative society which had formulated by a private people. According to Banking Regulation Act 1949, the following types of cooperative societies are excluded from its application. Okay, so there are some cooperative society which is excluded from the application of Banking Regulation Act 1949. Number one, central cooperative banks. Okay, so for central cooperative bank, this Banking Regulation Act 1949 is not applicable, and also it is not applicable for cooperative credit societies, and also it is not applicable for cooperative society without banking business. Okay, for these three sectors or a three kind of cooperative societies, this Banking Regulation Act of 1949 is not applicable. These exemptions are based on Act's provision. Okay, so there are some exemptions that is given by Banking Regulation Act 1949, that is exemption of a cooperative society, that is as per the act that is given under Banking Regulation Act 1949. So this distinguish is made by a Banking Regulation Act 1949 to know the difference between the cooperative society which had engaged in a banking activity, and there are number of cooperative society which is not engaged in banking activity. To make the difference between the cooperative societies which is engaged or not engaged, this act had introduced, right? So it is going to say the non-applicability of a Banking Regulation Act for the cooperative society, means different kind of cooperative society. Section 4, power to suspend operations of Act. According to Section 4 of Banking Regulation Act 1949, the Reserve Bank of India have a complete authority to suspend a gazette that is sent by a central government to the Reserve Bank of India. Means if there is any official gazette that is sent by, means rules and regulations or regarding any message that is conveyed by central government, the Reserve Bank of India have the complete authority to suspend the operation. So suspend the operations means within a specified period of time, it cannot be suspended long duration, right? The central government, if on representation made by Reserve Bank in this behalf is satisfied, that is expected to do so. So whatever a thing that the central government that is going to send to the Reserve Bank of India regarding the official gazette, so the Reserve Bank of India must follow all the regulations, right? So that is prescribed by Government of India. Maybe notification in the official gazette suspend for a such period not exceeding 60 days as may be specified in a notification. So according to Section 4, if any official gazette that is given by central government to a Reserve Bank of India, this Reserve Bank of India have the authority to suspend for the tenure of 60 days. It cannot suspend the operations more than 60 days. Means it must follow after 60 days the operation of all or any of the provisions of this act. So the complete operation or any of a provision of this act, either generally or relation to any specified banking company, either relation with any kind of a banking company. And again under Section 4, it is going to say that a governor of Reserve Bank of India, he do have a complete authority to suspend the operations. According to Section 4 of Banking Regulation Act 1949, the governor of Reserve Bank of India, he do have a authority or a power to suspend a operation for 30 days, not more than 30 days, right? So he have a right to suspend operation for 30 days, and in terms of an emergency situation, the deputy governor which had nominated by central government, he do have a complete right to suspend the duties. Copy of any notification issued under subsection 3 shall be laid on a table of a parliament as on as may be after it is issued. Whatever a notification that is made by a legislature, whatever a notification that is made by a central government, a copy of that official notification, that is gazette, must be circulated to a table of parliament. Means they are supposed to inform parliament about all the things that must be modified under a Banking Regulation Act. According to Section 5, it is going to say about interpretation. So there are three things it is going to mention about the Section 5. First one is about approved securities. Second one is about a banking, means actual meaning of a banking. The third one is about banking company. Okay. So when it comes in terms of approved securities, the securities that is issued by a banker, whether it is from the end of a state government or a central government, that must be approved by a Reserve Bank of India. Without approval of a Reserve Bank of India, the banker is not supposed to issue a securities, right? Whatever the securities that is issued by central or a state government or any other securities, that must be approved by Reserve Bank of India. It is a duty of a Reserve Bank of India to approve the securities before it get issued for a customer. So here, according to Section 5 of a Banking Regulation Act, they are going to say about a meaning of a banking. What exactly the bank is about according to a Banking Regulation Act 1949. So when it comes in terms of a banking, there are three questions that we need to know about, right? Question number 1, why? Question number 2, what? Whom? So these are the three questions that we need to know. Banking means accepting. So banking means it is a process of accepting. What it is going to accept? It is going to accept a deposit of money, right? A bank is going to accept a deposit of money. Why it is going to accept? For the purpose of lending or investment. It is going to lend the money that had collected, or in the terms of investment that it is going to utilize. So to whom it is going to lend for? To whom it is going to issue the money for? For the public, that is general public, it is going to give a money, right? There is an answer for three questions. I repeat, what it is going to accept? It is going to accept a deposit of money, right? Why it is going to accept? For the purpose of lending or investment. From whom it is going to accept? From a general public or a public. Repayable on demand or otherwise. So whatever the deposit that is collected by a banker, how he used to repay for a customer? By repayable on demand. Means if I do have a savings account, I can withdraw whenever it is required, right? So banker, he won't say that you are supposed to withdraw your money. Okay, so I'm supposed to withdraw my money whenever it is required, and hence a banker, he is going to facilitate its customer as per his demand. Okay, so if it is required, I can withdraw. If it is not required, I can keep in my bank account or otherwise. Means there are a few accounts where the amount will be easily encashed, means after a specified period of time. It may be recurring deposit account or fixed deposit account. So after the maturity of that particular account, the amount will be credited to our personal account, right? Next one. And withdrawable by check, draft or otherwise. If I want to encash the amount, I can withdraw the money by using a check, draft or otherwise. Means there are other payment mode where we can receive the payment and make a payment, means encash the money. By visiting ATM card, I can withdraw the money. So by all the kinds of online transaction mode, right? So Google Pay, Phone Pay, mobile banking, right? So these are all the things how I can transfer the money and get the money. I repeat the definition. Okay, this definition is very important in the exam point of view. Banking, a meaning of banking. This is a meaning that is given by a Banking Regulation Act 1949. This is a definition. Okay, this is a definition that is given by Banking Regulation Act 1949. Banking means accepting. Accepting what it is going to accept. It is going to accept a deposit of money. It is going to accept a deposit of money. Why it is going to accept? For the purpose of lending or investment. So what is the main intention of collecting the money? For the purpose of lending and investment. To whom it is going to lend? For the general public. and again payable on demand or otherwise. So there are various kinds of accounts. In terms of a savings account, so as per demand the banker is going to give the money, and in terms of otherwise means recurring deposit account or a fixed deposit account, after the maturity of a specified period of time it is going to credit for my personal account, means saving account. And withdrawable by check draft. So if I want to encash the money, so I can go with the check and draft, that is a traditional way. In terms of a modern methodology, that is online banking, so Google Pay, Phone Pay, right? So we can go with the mobile banking applications. So this is a definition that is given by Banking Regulation Act regarding banking. So what exactly the Banking Companies Act is about? According to Section 5, this banking company means a company which is going to follow all the kinds of banking activity. Means this banking company is not supposed to involve in any kind of trade activities, right? According to a Banking Regulation Act Section 5, this banking company does not have any authority to involve in any kind of trading activities, and it have a right to accept the deposit from the public solely for financing its business. So why it is going to accept the deposit? It is going to accept deposit for financing its business. Should not be deemed to be transacting the business of a banking company. It must not deem a transaction business of a banking company. Means according to the interpretation, banking company must not involve any kind of a trade activities. Okay, so it have only right to engage himself with other activities, means the activity which comes under a Banking Regulation Act means banking functions. Under Section 5, we need to learn three things: approved security, banking, third one is banking company. So according to the Banking Regulation Act 1949, a banking company is a company which go with a banking business. It doesn't have a right or authority to involve any kind of a trade activities. Means a banking company, it must not involve in any kind of a trade activities. Hence, it must follow only a banking functions. So, according to Section 5, that is interpretation, we are going to learn three things. Approved securities, Reserve Bank of India is going to approve the security. Banking, that is the definition that is given by a banker. So, banking company means a company which is going with the banking activities. Section 5A, Act to override memorandum articles, right? So, override means, so it need to find a way for a escapism or refuse to follow. Means this Banking Regulation Act refused to follow this articles and memorandum of association. So under Companies Act 1956 or 2013, each and every company must have two documents, that is a memorandum of association and articles of association, right? So what is this memorandum of association? This memorandum of association is going to describe about the company's relationship with the shareholders. This memorandum of association is going to describe about the relationship between a shareholder and a company, and also it is going to state the objectives of a company. Means all the objectives of the company must be mentioned under a memorandum of association. This articles of association is a legal document which is going to prescribe rules and regulations that is made by a company and how the company is going to formulate its operations day by day. It is going to mention all those things. So these are the very important documents, that is Memorandum of Association, Articles of Association, MOA and AOA, that you are going to study in depth in this. You are going to learn in company law. So according to Section 5A of Banking Regulation Act 1949, the Act shall override any provision contained in, right? So whatever the provision that is included in memorandum and articles of the association, okay, memorandum and articles of the association must not followed. Means it may avoid the provisions that is given by memorandum and articles of the association according to Section 5A. And also agreements that is executed by the banking company, it have a complete right or the authority to avoid the agreement that is executed by a banking company. In the next session, we are going with part 2, that is a business of a banking company. So it is a part 2 of a Banking Regulation Act 1949, and also this part 1 Banking Regulation Act 1949 preliminary. It is very important in the exam point of view. They may ask this question for 10 or 15 marks. Please get prepared for this all 6 points. So they may ask in a final exam for 10 or 15 marks. Thank you.